Hey, welcome back to my YouTube channel. Now, if you've been hiding under a rock, L.A. Reid fails to have his S-word assault case thrown out. Now, back in 2023, Drew Dixon filed a S-word lawsuit on L.A. Reid. Now, I have the court documents. Stay tuned. All right, before we get started, let's make sure we have our copyright disclaimer under Section 107 of the Copyright Act. Just letting everyone know that this is made for fair use. We are not a paralegal, we're not an attorney, and we're not a judge. We're just simply saying that we know how to read. And what we will be doing today is reading public record court documents. All right, let's get started. All right, and we're back. Now, as you can see on your screen, we got the court documents, okay? Now, this was filed back on August the 13th, okay? Let's get into it. On November the 8th, 2023, relying on the New York Adult Survivors Act, Drew Dixon sued Antonio Marquez, known as L.A. Reid, alleging that he S-word assaulted her twice during the course of her employment at Arista Records approximately 20 years ago. Plaintiff asserts 4 causes of action: S-word battery and assault, false imprisonment, intentional infliction of emotional distress, and a violation of the New York City Gender Motivated Violence Act. All right. Now, under that, you do have codes. Pause your screen if you would like to research those codes. Do so at this time. All right, we're going to keep moving. Defendant moved to discuss counts 2 and 3 of the complaint pursuant to federal rules of civil procedures 12b6 and 12b3, and to strike portions of count 1. Now, as y'all take a look there, for the reasons discussed below, defendant's motions are denied. Now, as we scroll down, keep in mind these 4 cases or 4 causes of action: S-word battery and assault, false imprisonment, intentional infliction of emotional distress, and a violation of the New York City Gender Motivated Violence Act. Keep note of that as we scroll down, okay? Now, page 2 mainly goes over the background of the case, and as you read above, there was 2 incidents of S-word assault, okay? Pause your screen if you would like to read. We're going to scroll down, okay? So let's look at page 3, okay? You see right here where it says discussion? Let's read that, okay? Defendant 12b6 motion to discuss counts 2 and 3 is denied, okay? A, legal standard: to survive a motion to dismiss under Rule 12b6, a complaint must allege sufficient facts taken as true to state a plausible claim for relief. More codes. Pause your screen if you'd like to research that. Do so at this time and then come back to the video, okay? A claim has facial plausibility when the pleaded factual content allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. More codes. A complaint does not need to contain detailed or elaborate factual allegations, but only allegations sufficient to raise an entitlement to relief above the speculative level. More codes. All right. It says the court is not required to credit mere conclusory statements or threadbare. Ooh. All right. Let's take a look here. Now, remember above, I told y'all to keep those 4 causes in mind. Now, this is page 4, so let's scroll back to page 1 if you missed out on what I said. A plaintiff asserts 4 causes of action: S-word battery and assault, false imprisonment, intentional infliction of emotional distress, and a violation of New York City Gender Motivated Violence Act. Now, let's go back down to page 4, okay? It says that defendant moves to dismiss count 2, which is false imprisonment, and count 3, which is intentional infliction of emotional distress. arguing that they are time barred. Well, it seems to me that, how time barred was that? Well, let's keep reading. Now, remember, this is 15 pages, so we're going to go through this pretty quickly. However, I will show you every page, and if you would like to pause on the screen at your time or your leisure to read, then do so, okay? Uh, it says he contends that these counts are subject to New York's 1 year statute of limitations contained in you see this code here. Look it up on your time, okay? And that neither is covered by nor revived by the ASA. It says count 2 and 3 are timely. The ASA revives every civil claim or cause of action brought against any party alleging intentional or negligent acts or omissions by a person for physical, psychological, or other injury or condition suffered as a result of conduct which would constitute a S-word offense as defined in Article 130 of the Penal Law. Okay? According to ASA covers civil claims related to intentional torts, false imprisonment, that were suffered as a result of conduct that otherwise would be a S-word offense under New York Penal L. As you can take a look here, another code. Ooh, plaintiff false imprisonment and IIED claims clearly arise from the alleged S-word assaults, although there is a dearth of cases analyzing similar claims under the ASA. A few that have the weight of authority supports the conclusion that plaintiff's claims were revived by the ASA. All right, let's scroll over to page 5. All right. In Wilkie, however you say that, when considering a claim by an adult, the court looked to the CVA Woo's relevant statutory, how do you say that, law, language, is identical to that of the ASA. Okay, pause your screen, take a look. All right, let's go over to C. Defendant motion to discuss the false imprisonment claim for failure to state a claim is denied. Defendant also moves to discuss the false imprisonment claim pursuant to, as you see, another code. To state a civil claim of false imprisonment, a plaintiff must allege facts from which the court can plausibly infer that 1. The defendant intended to confine the plaintiff. 2. The plaintiff was conscious of the confinement. 3. The plaintiff did not consent to the confinement. And 4. The confinement was not otherwise privileged. And as you see here, just pause your screen. We're going to keep going. All right. Plaintiff correctly notes that this is a civil case, so she must only allege the elements of a civil claim for false imprisonment under state law. Plaintiff argues that she easily cleared that hurdle. In support, plaintiff relies on Moore versus Sam's Club, okay, in which plaintiff manager enclosed the plaintiff in his office, pushed her against a filing cabinet, and tried to place plaintiff's hands on his private parts. Wow. The court denied the defendant's motion to dismiss, as it was reasonable to infer the manager's intent as well as the plaintiff's consciousness and lack of consent. All right, starting with the alleged incident of the private plane, the complaint alleges that Karen Koch, a VP of Arista, advised plaintiff not to book a flight to the retreat as she had been invited with a group of executives to join defendant on a private flight. It was only after arriving that plaintiff realized that no one else would be accompanying them in the flight. The only element of defendant seriously challenges is the third, whether plaintiff adequately alleges that she did not consent to her confinement. All right, pause your screen. All right, we're going to keep going. Let's see here. Also, to the second incident, plaintiff alleges that defendant lured her into accepting a ride in a cart with him by representing that he would listen to music that she wanted him to review. Oh, okay. While plaintiff consented to the ride, she did not consent to the defendant's alleged actions once she was inside of the car. As with the plane ride, it is in question. It's a question of fact whether plaintiff consent continued after the defendant began to assault her. All right, pause your screen. All right, let's read. All right, defendant motion to discuss the intentional infliction of emotional distress claim for failure to state a claim is denied. To allege an IIED claim, now that's an acronym, as we read above, the plaintiff must allege I, extreme or outrageous conduct, intent to cause, or disregard of a substantial probability of causing severe emotional distress, a causal connection between the conduct and the injury, severe emotional distress. More codes. All right, pause the screen. Let's keep going. All right, we're just going to keep going here. Pause your screen. So basically, what these court documents are saying is that when it comes to his argument, it is protected. So much as far as him saying about the New York law when it comes down to the statute of limitations and the time framing, as Drew Diction mentioned here, that she did it properly. All right. All right. Y'all take a look here. All right. We're almost finished. Just pause the screen and keep reading. All right. As y'all see here, defendant motion to strike the 4 Article 130 citations is denied. Motions to strike are disfavored, as courts should not decide to strike a portion of the complaint on the grounds that the material could not possibly be relevant on the sterile field of the pleadings alone. Without a single citation to to case law, defendant attempts to meet the high threshold necessary to prevail on a Rule 12F motion and misses the mark, although defendant quarrels with whether his actions rendered plaintiff physically helpless, as required by sanctions 130.65 and 130.66 and 130.67, that is insufficient to strike the challenge's citations. So here's the entire court documents. You can go back to the very first beginning, and yeah, we are done. All right, if you enjoyed the content, make sure that you like this video, share this video, but most importantly, subscribe to the channel. All right, take care.